Hi, y'all. Welcome. So, today we are going to be going through some immigration news. Even though a lot of you are looking at the new administration coming in January, we still have immigration news going on, right? Things that are applying now. So, you still need to be aware of those. I get it. You're worried about January, but there's things changing today that you need to know about. So in this video, I'm going to be talking about those new changes, especially with the green card application. You really need to you really need to know about these things because it is changing. There's a new form, there's new requirements. So we're going to be talking about that in detail today. So the first change, like I said, changes with the green card application is happening. So the first change is with the medical exam requirement, okay? If you are applying for a green card in the past, right? Before December 2nd, you can apply for your green card and wait for USCIS to tell you to send the medical exam, or you take the medical exam to your interview. That's no longer the case, okay? If you're applying for the green card, you need to include the medical exam. So anyone filed after December 2nd that does not have a medical exam report included may be rejected. I have a feeling that like if you send it in on the 2nd or the 3rd, USCIS may let it slide, but anything from now on, you need to include the report or they can reject your whole application and you still have to do that medical report. For our clients, we have cases ready to go, right? As of December 2nd, that we had to put a pause on because we want to make sure that they had that medical exam and avoid any further delays. Because guess what happens? When they reject your application, it can take them up to 2 weeks, right? It can take up to 2 weeks for you to know that your application was rejected. And then you still have to do the medical exam. So you want to make sure that you're doing it and avoiding those delays because 2 weeks of not knowing that whether your application is accepted or not, and then having to do the medical exam, which can take another 2 weeks. So that's already 4 weeks gone that your application could have been pending. So just make sure if you're filing your green card application that you're including that medical exam report so that you don't end up having your application rejected. All right. If you are joining me live and you have questions, please go ahead and put them in the comments. I am more than happy to answer your questions as we go along. If you're watching on the replay and you have questions, put them in the comments as well. All right, so next thing with the green card application, it's the month of the green card application changes. USCIS has updated the form. So the I-485 is now different. So they updated the categories as far as, what is your green card application based on, right? If you say it's based on family, who is the family member that your green card application is based on. So they really went into more detail on those. They have this question now about whether you were a crew member. They have 2 questions on this that were not there before. So they put it right up front. So it's not on the immigration questions. It's not on the security questions. It's literally on the first couple pages that they want to know. Were you a crew member? Were you coming to the U.S. to join a crew, to join an airline? Were you in that situation? So they are asking those questions up front and not just in the immigration sections. They are also spelling out who qualifies for an exemption from the affidavit of support. So if you're filing a green card application, you know that there's certain situations where you may be exempt from having to file an affidavit of support. Most people filing based on marriage are going to have to file an affidavit of support. But there are situations where you may be exempt. And now USCIS is making it extremely clear on the form what those situations are. And if you feel that you fit one of those, you can check it off. And that means you don't have to file an affidavit of support. You don't need a sponsor. The one that most people may qualify for is if you are filing a green card application based on marriage. The only exemption you may have is if you have legally worked in the US for 10 years, right? If you have 40 qualifying quarters, which rounds out to 10 years. And the only way to know that is by contacting the Social Security Administration, and they have to give you paperwork saying that you qualify. You have 40 qualifying quarters, and then you don't have to file an affidavit of support. Again, that is if you have legal rights to work in the US. So working in the US on its own, filing a tax return is not enough. The Social Security Administration needs to see your Social Security number, verify that it's you, and then say that you met the 40 qualifying quarters. So there's steps to it. The next thing that changed, okay, this is new on the forms, is it asks you for 5 years of either employment or education history. So if you have only worked for the past 5 years, you only put employment history. If you have worked and went to school, you'll put both. If you have only went to school for the past 5 years, you'll just put your school. Now, it now has this particular section. So before it would just ask you the name of where you worked, your the address, what your title was, things like that, right? Normal. But now it has an additional line that says, if unemployed or retired, source of financial support. So now, if you put on your green card application that you are unemployed or that you are now retired, they want to know, how are you supporting yourself, right? Where is the financial support coming from? Again, this all ties into what the next section does, all right? So they want to know, how are you supporting yourself in the US if you're saying that you do not work, you don't have employment, or that you're retired? How are you supporting yourself? If you have an affidavit of support, if you're a parent living with your children and your children are financially supporting you, that's your answer, right? If you are married and your spouse is supporting you, that's your answer. So that, don't make it overcomplicated, all right? Don't make it overcomplicated. And then the next section after that is the public charge section. This is not what they typically do, right? The application before will just ask you certain questions to see, your household size, household income, and debt, and all of those things. But now they have a specific section on the public charge grounds where they spell out who is now subject to the public charge grounds. So in some ways, it's just more paperwork. Honestly, it's now 24 pages of information that you need to put in, but it does help by spelling out who needs an affidavit of support, who is exempt, who is not exempt. So, like I said, if you're filing based on marriage, or if you're filing based on your parents being US citizens, but you're over the age of 18, you need an affidavit of support, right? If your child is filing for you, you need an affidavit of support. So when you go on the form, there's going to be like a bunch of options of who does not need an affidavit of support. You may not fit into that, okay? You may not fit into it. So just know that. And also, it has it's not just who needs an affidavit of support, but who's even subject to the public charge rules, right? If you're subject to the public charge rules, then you need to worry about the affidavit of support. If you are not subject to the public charge rule, the affidavit of support never even comes up. So just keep that in mind. And then once you determine that you do not fit into an exemption for the public charge rule, then you have to put your household size, your household income, household assets, liabilities, what's the highest grade or degree that you have received, not members of your household, but you, the intended immigrant. What is the highest school you have completed? What's the highest degree that you have? They have options there. And then if you have any certifications, licenses, skills, experiences that you believe will make you attractive for employment, you want to list it under the certifications. Then they want to, of course, know if you've received any cash assistance from the US government. So that's really important. And if you say yes, they want to know what those are. All right. And then, have you ever been institutionalized at the government's expense? So they're not asking if you have ever been institutionalized, but they're asking, did the government have to pay for it? Or was it paid for by you or your family? So if it was not paid for by the government, the answer to this is no. And when they say government, they mean US government. So if you were institutionalized in another country and the government of that country paid for it, that's not really what this is asking for. They're asking, did the US government have to pay for you to be institutionalized? All right. So those are the biggest updates on the I-485. I do see a question in the comments that I will get to. If you're joining me live and you have questions, please put them in the comments. Feel free to say hi. But we're going to be going through these. There's not a lot of changes because, again, we are anticipating a new administration. So the U.S. immigration system is kind of just chugging along. So there's not going to be a lot of news, but the biggest one is the changes to the green card application, the I-485. There's two big ones. The form is going to change, and if you are filing a green card application on or after February 10, 2025, please make sure you're using the current forms, okay? The forms that were in place before this one came in is only good up until February 9, 2025. So if you already filled out the forms, and then you can use that, right? If you already filled out the forms and you know you're going to file your application before February 10, 2025, then use the old forms. But if you are not sure, if you think you may need to wait till after February 10, on or after February 10 to file your green card application, just make sure that you are filing with the most recent form, okay? All right. So question. Hi, Prince. I have a pending DNA test to attend, but my name arrangement on the appointment letter is different from the name arrangement on my ID. I would have to provide. Will it be a problem? It depends. So it's going to depend. Is it that the first name is mixed up with the last name? So it's going to depend if the officer at the embassy can still verify that it's you. Because if the name difference is a lot, they may not be able to verify that it's you. So the ID is really to verify that it's you. And also remember that sometimes they will put the last name first. So the embassy does this a lot, where they will put the last name first and then the first name. So don't think that it's wrong. I know for immigrant visas, we see that a lot, where they will put the person's last name first and then their first name and middle name. So if that's the case in your situation, it could be that it's not wrong, right? You may see it as wrong, but the embassy may not see it as wrong. So, and typically the DNA test is also based on applications filed. So if your application shows the name in that arrangement, you may want to update your application to have the right arrangement of your name, but at the same time, just know that sometimes the embassy does put the last name as the first name, and sometimes they put it in the correct order. So just know, if it's just that the last name is in the front, don't assume that it's wrong. Okay, don't assume that it's wrong. All right. So next question. Hello. I lost my job. Can I use this to speed up my case, expedite with USCIS? It depends, right? It depends what application you have pending. So if you have a green card application pending and a work permit application pending, a job loss may be appropriate to expedite uh, a work permit, right? If you can get another job offer and it's just you need that work permit to get the new job, then yes, you can use that to expedite. If you filed the I-130, the question is, so if you're the petitioner on the I-130 and you want to get that expedited because you lost your job, the question is going to be, how do you connect the I-130 pending to your job loss, right? So there needs to be some kind of tie between the job loss and the application that you're trying to expedite. What is the emergency, right? What is the humanitarian purpose? So that's what it really comes down to. So just know it's not that you can't. Remember that. It's not that you can't ask for an expedite. Typically, I tell people, apply for an expedite. Worst case scenario, they say no. Okay? Worst case scenario, they say no. We're not going to expedite your case. But when you are thinking through the expedite, you need to make sure that it actually fits the humanitarian grounds. So if you are the beneficiary of an I-130, the question again is there a green card application attached to that? Is there a work permit attached to that? Because for an I-130, the petitioner is the one that has to show the urgency, right? So the beneficiary losing their job does not really lead to an I-130 being expedited unless you can show how that the beneficiary losing their job affects the petitioner and why the case should be sped up, right? So there's just, you kind of have to tie the two together to make it make sense for USCIS to be able to show that urgency in your situation. Because remember, every time that you do an expedite request, you're basically telling USCIS, hey, I want you to put everyone else's case on hold real quick and go ahead and approve mine so that I can get to the next stage. And then you can get back to everyone else's case. So when they're talking about emergency, they do mean that that they want that urgency, right? They want to see why it's urgent for your case to be moved ahead of everyone else's. All right, next. All right, so next question. I filed for I-751 based on cruelty and submitted documents and divorce. I got a notification for an RFE and scared. Would by any chance know why and what the RFE will entail or needed? No, right? Unfortunately, each RFE is specific to the case. So they don't just send out general RFEs. You may get an RFE based on needing additional documentation of the relationship or additional documentation of the abuse, right? But it's going to be very specific to your situation. So you need to wait for that RFE to come in the mail and you need to look at it first, okay, before you get scared. See what they're asking for. I've received RFEs where they're literally asking for one document, right? So request for evidence does not mean your case is all of a sudden going to be denied. A request for evidence just means that USCIS needs more evidence from you, right? They need more documentation to have everything they need to approve your case or to make a final decision on your case. So an RFE, I'm not mad at an RFE because it tells you exactly what they need from you. Okay, the RFE just tells you exactly what they need from you, and that's how you will know, right? Once you get that RFE, you will know exactly what they need, what you need to show in order for your case to be approved. Right? They will sometimes, and it will give you clues of where your case may have been weak to start with, and you can just add more documentation to fix it. All right. So what the RFE will entail or need, I will not know, right? You need the actual RFE in your hand to know that information. USCIS does not, like I said, no general RFEs just being thrown around. And like I said, RFEs in some situations are a good thing. It's not a notice of intent to deny, okay? An RFE is just a request for evidence. A notice of intent to deny is harsher, right? When you see that, you're like, okay, now we're going to fight, right? So don't freak out over the RFE. Just see what it is first and then move from there. If you get a notice of intent to deny, for everyone else out there, that you need to take it seriously, okay? Because you only have like 30 days to respond to a notice of intent to deny, whereas an RFE, they may give you up to 87 days to respond to it. So it's just RFEs, I'm not super scared of those in my office because it just tells me exactly what I need to give them for them to go ahead and approve the case. All right. Next question. Okay. Hi. So again, I always tell y'all when you have updates on your case, feel free to share because I love it. So D is saying that they received they sent me a message last week on my last live telling me that their I-130 has been approved. Now the I-130 has been sent to the National Visa Center so they can actually start the visa application. Honestly, just seeing the growth, like where you go from, worrying about is the I-130 going to be approved to now, right? To now being like, oh, now I have to file my DS-260 and all of that. Amazing, amazing. So I love seeing the growth. Keep me updated, please. All right, so Prince is following up on his question about the name. The name arrangement is from the RFE we received and the application we filed, but the two first names, one middle name, and one last name on my ID. Okay. So if it's just that, all right, honestly, when it comes to first names and middle names, if it's just that they put the first name, I'm trying to think of the best way to put this. If your last name and your first name is there, and then the middle names are like mixed up or whatever, it's usually fine. But you should get that corrected, right? That should be corrected with USCIS. So anytime there's a mistake on that application, even with a name, right? Whenever there's a mistake, if they mix your middle names up or they mix your first names up, you want to always, always, always reach out to USCIS and ask them to fix it, right? You can tell them that you made a mistake. It's okay to admit that you made a mistake. And I know a lot of us don't want to, but it's okay to admit that you made a mistake. And typically they will fix that. All right. We had a situation where the client's first name was basically not anywhere on the form because we filed online and USCIS on the website literally put his last name as his first name and also as his last name. Right? So what we ended up doing is doing a typographical error request with USCIS, letting them know, hey, the name is wrong. We need that fixed. The first name is this, but on the form it says it's his last name. You have all his documents to verify that it's him, and they'd fix that. Like within 30 days, it was fixed. So don't be afraid if you know, mess up a name on your forms. You can always ask for it to be fixed, especially if the case is still open with USCIS. Okay. When it gets to the embassy, you can't fix an I-130 once it's been approved. Okay. If it's open, you can still fix it. So don't be afraid to ask for that to be fixed. All right. Mohammed, the CR1 and IR1, which one do you think is the best and faster? This is a great question. You know what? I'm gonna put it right there. This is a great question. You want to know why this is a great question? Because people get this mixed up all the time. So both of those are based on marriage to a U.S. citizen. A CR1 and an IR1 is for spouses of U.S. citizens. The only difference, right, is that for the CR1, it means that your marriage is less than 2 years old when you got your visa. For the IR1, it means that your marriage is more than 2 years old when you got your visa. That's the only difference there. The processing is the same. Everything is the same. You don't even get to pick whether it's CR1 or IR1. It's just automatic based on when you got married, right? How long ago your marriage was. That's what it's based on. You don't actually get to pick if it's CR1 or IR1. So I'm so glad you asked that question because people ask me that all the time. But most of the time, people ask me between the K1, the fiancé visa, and the marriage-based visa, which one is faster. But this is a great question as well. For most countries right now, if I'm being honest, for most countries right now, we are seeing the fiancé visa be faster than the marriage-based visa. That's for sure. But as far as CR1 and IR1, there's no difference. It's the same thing. It's just how old is the marriage when the visa is approved, because it's both based on marriage to a U.S. citizen. Remember that part. All right. Hi, True. I'm glad you caught it live. All right. My husband is here on a TPS and is a Haitian national. I'm so worried about his status, thinking we will have to move. We have a lawyer, but scared. That is true. Unfortunately, that is very normal, right? The fear is normal. If no one has told you that, I will tell you that the fear is normal. There's a lot of people in your situation that feel the same way. What I will say is not instead of, right? You're allowed to be afraid. You are allowed to be scared. But also, you need to look at what can he qualify for that can have him here permanent, right? Is he in immigration court proceedings? If he is not, that's good, okay? If he is in immigration court proceedings, maybe think about trying to get his case closed so he can be out of immigration court proceedings. That's basically what we are doing right now for our clients with TPS, is looking at, are they in immigration court? If they are not in immigration court, the level of fear goes down, right? If they are in immigration court, can we get that case closed based on the fact that they have TPS? And then we also look at what else do they qualify for, right? Is there anything else at all they qualify for? We look at asylum, family-based petitions. If they entered with parole, you want to go ahead and it looks like you two are married. If he enter with parole, you want to start the green card process. Now, that's a great question. All right. So true, that's great. So he entered with documentation. That's amazing. That makes it that should bring down your fear. Okay? He came in with documentation. Then he has TPS, which is an actual status that he's currently in. And then you said that, okay, I will see what the lawyer says. We are in the midst of doing immunizations. Yeah. So just know, if you two are married, he came in with documentation, file, right? If he has no other thing that makes him inadmissible, right, other than the fact that he may have overstayed his visa or whatever that may be, you want to, yeah. So if the only thing that he did was enter with a visa or enter with parole and has stayed past the parole period or stayed past the visa period, you can apply for him. Okay, you being a U.S. citizen, I'm guessing from your questions, right? If you're a U.S. citizen, you'll be able to file for a spouse, and if that spouse has a legal entry into the U.S. and just has some unlawful presence in the U.S., the fact that the U.S. citizen is a U.S. citizen waives the unlawful presence. Okay, if he's ever worked without authorization, you being a U.S. citizen waives the unlawful the work, right? So what I'm suggesting to my clients that are married to U.S. citizens that are scared is look at, do they qualify to adjust their status in the U.S.? And if they qualify to adjust their status in the U.S., we're filing an adjustment of status application for them immediately. All right. So, but just know, like you mentioned, that medical report, you need that to file now, to file the green card application. So get that done. Get your application in as soon as you can. That will make you feel better. Okay. If nothing else, once you have sent your application and you get that receipt notice in your hand, you are going to feel way more calmer. Because right now it's just a lot, right? It's just a lot that you have to think about. What if something changes with TPS? What if something changes with what you're already planning on doing? But get your application in. My recommendation to everyone, get your application in before the 20th, right? Because most of the time when this changes, it applies to future applications, not applications in the past, unless there's specific language in the rules or the law that says it's retroactive, which is not typical in immigration cases. So get your applications in. All right. So next question. Do you think people with credible asylum cases should be worried in Trump administration? Should you be worried? It's not really about being worried whether you have credible asylum. Is that the chances of winning an asylum case under the Trump administration is going to be much harder, depending on your reason for seeking asylum, right? Most people that file an asylum claim, it is credible. They do have genuine fear, right? They have a fear of going back home because there's someone or an entity that's after them. And it's probably because of one of the protected grounds. Now, what those protected grounds are will shift will shift under the Trump administration. And part of that is if the category is under why am I going blank? So if it's not race, gender, particular social group, right? If your asylum is based on you being a part of a particular social group, you're going to most likely have a harder time under the Trump administration than if it's based on political opinion or your race, your gender, things like that. So that's what we're looking at as far as the effect it will have. But if you have a credible asylum case and you have filed your asylum application with USCIS or with immigration court, just know typically when you receive your receipt notice, it says on there that you can remain in the US until a decision is made on your asylum case. Okay, it says it on the receipt notice. I know it's scary, but once you have filed your asylum application and you have your receipt notice that shows that you have filed it, you should really look at it, because it says that you are allowed to remain in the US until a decision has been made on your application. All right. So you're not doing anything wrong if you have an asylum case pending and you're still physically in the US. Because let me tell you something. The only way for you to apply for asylum in the US is to be physically present in the US. Okay? That's the only way. If you leave the US before your before a decision is made on your asylum application, you are going to be abandoning your asylum application. If you're in court and you miss the court date, you're going to be ordered removed in absentia. So as long as you have your application pending, you're fine as far as like deportation is concerned. But the more the thing that I'm most worried about is the people that theirs is under the particular social group, is if that what fits under a particular social group is most likely going to shrink under the Trump administration. All right, next question. My I-765 have been pending for a year and they just denied. Do you think it's because of my I-130 pending? It depends what your I-765 is based on, right? If your I-765 is based on your green card application, first you need to wait to see what the denial notice says, right? That's one thing that it's like a love-hate relationship that I have with the online account, the USCIS online account, and the apps that will like give you an update on your case anytime something changes. Love-hate relationship with them, because you see the notice and it doesn't tell you why, right? It's not going to tell you right there why it was denied. You have to wait sometimes up to a week to get the letter in the mail, and you've had a whole week freaking out over it, right? So before you start guessing maybe it has to do with this or that, wait for the denial notice to come in. It will tell you exactly why it was denied. And then you can decide if it's something that can be fixed. And if it's something that like, oh, you didn't include this, or oh, you don't qualify under this category. Because sometimes it's the category that's the issue. Right. So if you are filing based on asylum and instead of putting C8, you put C9. C9 is based on marriage, a green card application. And then C8 is based on an asylum application pending. So something as simple as the category being wrong can lead to the denial. So don't freak out. Find out what it is, and if it's something that you can show that you still qualify, or that immigration is wrong, and you can send in additional documentation with your next application, do that. So in most situations, depending on the reason, we typically refile the work permit unless it's like something, financial hardship or things like that, where we would maybe want to do a service motion with USCIS to see if they will reopen it without having you pay a fee. But it's sometimes just cheaper instead of filing like a motion or all of that to just file a new application and just make sure that your new application addresses whatever the reason is that the old one was denied. Okay? But don't assume that it's because of the I-130. Don't assume that. It may be because of it, but don't assume it until you see the denial notice. So anytime, for all of you out there, anytime you see that update that says, oh, an action was taken on your case, there's a request for evidence, there's a notice of intent to deny, there's a denial, right? Whenever you see those things, wait for the letter to come to you, right? Before you freak out. I know you're going to freak out, but before you do, just remind yourself, I still have to wait for the letter to come in so I know why this was denied, and then I can plan, right? So right now, it's still coming to you. You don't even know how to plan to fix it. That's the main thing. Like, you can't fix it until you get that letter. So don't freak out, wait for the letter, and then make a plan of what your next steps are going to be. All right. Let me just make sure. Okay, so those are all the questions I see so far. So if you have questions, please feel free to put them in the comments. If you are just joining me, the biggest news of the month is that we're going to get we already have a new I-485 form on the USCIS website. So if you go on the USCIS website, the only I-485 that you're going to see right up front is going to be the new one. If you want to use the old one, you have to click a bunch of links before you get to the old one. But the new one is the one that's prominent on the website. Starting February 10, 2025, USCIS will only accept the new application. They will not accept the current ones that people are using. All right. Another change is that as of December 2nd, when you're filing an I-485, you need to make sure that you're including the medical exam report with that. If you do not include the medical exam report, just know USCIS can choose to reject your application. Okay, that's a big deal because before you could bring the medical exam to your interview, or if they're not going to schedule you for an interview, they may ask you to send it to them by sending a request for evidence. So they basically don't want to do either of those anymore. They want you to send it with the green card application and save them the steps of sending you an RFE or waiting till the interview to get the report. So those are the two big ones. And then there's one more thing. If you have an approved EAD card, so work permit, that is about to expire and you fit into the automatic extension, it's really important because there's certain categories of people that can get their EAD automatically extended. So before it was 180 days, then COVID happens and they switched it to 540 days. And then COVID ended and they went back to the 180 days. Wow. It's just the cycle. So now it is back to 540 days, and this is a permanent extension. Okay, so if you fit into the category of people that can get that automatic extension and you file your renewal application before your current card expires, that's the key. Okay, you need to file the renewal before the card expires in order to get the automatic extension. But moving forward, that automatic extension is now going to be 540 days instead of 180 days. So that's a great thing. That's something that was done during COVID that everyone was happy with. And then USCIS did away with it. Now they're coming back to it. So that is great. Hopefully it remains that way under the Trump administration. But if anything changes with the forms or the extensions, anything like that, I will be bringing those to you. All right. Couple more questions. If an IR2 immigrant visa is approved and the applicant moves to the US, what type of green card will they receive? And do they have to file the I-485 again? So if you're coming to the US with an immigrant visa, you do not have to file an I-485. The second you enter the US with your immigrant visa, it turns into a green card. Okay? So the second you come in with that, it turns into a green card. And IR2 is going to get a 10-year green card. So that's the difference. Someone asked before about the CR1 and the IR1, which is just the C means conditional resident. Okay, that's just what the difference is. The C just means conditional. If there's no C in your numbers, then you are getting the 10-year card and you do not have to file to remove any of the conditions. So that's what the person will get. Is the second you enter the US, you are now officially a permanent resident. You do need to pay the USCIS fee for them to print the card and send it to you, but that's all you have to do. Is literally like enter your information on the USCIS website, pay the fee, and they'll send it to you. So there's no additional thing. So IR is immediate relative. Yeah. So that is specifically, the IR1 is specifically for spouses of US citizens. Okay. So it just depends on your relationship to your petitioner. It does not it does not make a huge difference. So if you're coming in with an immigrant visa, you're getting a 10-year one unless it says that it's conditional. All right. So that's really the main thing there. My nephew is a green card holder. He did time for drugs. Should he be worried when the new administration comes in? Yes. Yes. And it also, yes, but it depends on the drug. So, for example, if it's marijuana possession under a certain grams, I believe it's like 30 grams, it's okay because there may be a waiver available. If it's like intent to distribute, things like that, those are deportable offenses. All right. So what I typically, when that is the situation and we know that it's a deportable offense, we look at is this person already a US citizen? Right? And that may be something that, not everyone is the answer is not going to be yes for everyone. That's really important. The answer is not going to be yes for everyone, but there are certain people that are already US citizens and just never know it. Right? They just never know it. They're just moving through life thinking they're just green card holders, but they're actually US citizens. And if they automatically derive citizenship from parents, then that doesn't matter because they were a citizen. Okay, so that's really the key. Did your nephew get their green card through their family, right? Through their parents? And were their parents US citizens before he turned 18? And did they already have 5 years physical presence in the US before he turned 18? If they meet the requirements for him to automatically derive citizenship, then that may be the option, right? So, but there's some analysis that needs to be done there to figure out if he's already a US citizen. And if the answer is yes, then get a certificate of citizenship, get a US passport, something to prove that you're a US citizen. But that's not going to apply to everyone. It is not going to apply to everyone, but if it does apply to him, that should definitely be something being explored with an immigration lawyer. All right. All right. So if you have questions, feel free to put them in the comments. All right. Just making sure I don't see any more questions. Um, and then if you're watching this video and you are getting value out of it, don't forget to like the video. If you're not already subscribed, go ahead and subscribe and share this video with people. Honestly, your questions are so important, and there are people out there that have the same exact question as you. They just don't know, they may not feel comfortable asking online, but you want to share this so that they can get the information that they are looking for, right? And make sure that they are taking steps to make their immigration journey easier. That's really key here. But yeah, that is so. Okay. Cruising26 on Instagram is asking, please, what's form I-212, so 212. So that's a waiver application. So typically the 212 is for someone that was already deported from the US, or someone that had a permanent bar to the US. In those situations, if the person was deported and they want to apply for a visa back to the US, they will need a 212 waiver. Okay, so that's what that waiver is, and that is done on form 212. I-212. USCIS kind of makes it easy when it comes to their form names and what it stands for, right? So they'll be like, you need a 212 waiver. What form do you need for that? 212. So yeah. Prince, and IR2 is for immediate relatives of U.S. citizens. So children of U.S. citizens. That's what that means. Yeah. So you are an unmarried child of a U.S. citizen. I hope that answers your question. So whenever you see IR2, just know it's for a child, and the parents that petition for them are a U.S. citizen. So that's what that category is. So IR1 is for spouses of U.S. citizens, and then IR2 are for unmarried children of U.S. citizens. Okay. And remember, that needs to fit under the, it's a little weird. So that is also for children under the age of 21, and there's a whole steps to children, right? So most of the time when people say children, we kind of need to be clear on what that means for immigration purposes. So children under that category is unmarried, because once you are married, you're no longer considered a child under immigration law, right? Under immigration law, it doesn't matter if you're like 18 years old. If you're married, you're no longer a child under your parents. It's a different category now. And then if the child is over the age of 21, it's going to be a different category as well. So IR2 is immediate relative, and that's children, and that child has to be under the age of 21 and unmarried. Okay, if they're over the age of 21, no longer IR2. If they're married, no longer IR2. The parents can still file for them. Okay, right? Your parents can still file for them, but they're going to be under a different category, and it's going to take longer. So they're going to be under a preference category instead of immediate relative category. So, all right. I hope that answered all your questions. Thank you all so much for joining me. It's a blast as always. We did go over the new forms for the I-485. It goes into effect February 10th. So if you want to use the old forms, make sure your application is filed before February 10th. And then after that, you will be rejected. They will reject it, okay? And then make sure that you are including your medical exam with your I-485 because they can reject your application. In the language, they said they may reject your application, but do you really want to take the chance that they reject your application? Like I said before, when you file an application with USCIS and they reject it, sometimes it can take up to 2 weeks for them to get it back to you, for you to even know that it's rejected, right? That's the only way you know that it's been rejected is when you get the packet back in the mail. All right, so that can take up to 2 weeks, and then you still have to do the medical exam, which can take another 2 weeks, if not more, depending on how many vaccinations you need and testing and all of that. So that's already 4 weeks behind schedule. So you want to make sure you have everything and you file all your applications at once, including the medical, so that you do not get a rejection, because those suck. I'll be honest with you. I hate rejections. Um, but you want to make sure that you do not get rejected. Just include the medical exam. And then the EAD cards are going to be permanently extended from 180 days to 540 days. So if you qualify for an automatic extension, make sure that you're filing your renewal for your EAD card before the EAD card expires. That's the only way you will qualify for the extension. Okay, if you file it after it expires, you are out of luck. You have to wait for it to be renewed before you'll have proof of your employment authorization. All right, so that is all I have for you today. Thank y'all so much for joining me. We'll probably do couple more Q&As before the end of the year. But yes, please keep asking me questions. Let's keep talking. And if you would like a private consultation where I actually talk about your particular situation, we go through your qualifications. What do you qualify for? What can you apply for? And then see if we can work together to make those things happen. You can do that by scheduling a strategy session with me. By going to my website, lilylegal.com, and clicking on contact us, and you can actually select a date and time that works best for you for us to chat. Or you can call my office at 508-443-1788. Oh, I see a question. All right. Well, thank y'all so much, and I will see you next time.